Section 32, Operation of the Act Bail. The immediate operation of the Habeas Corpus Act, says Amos, was not to dispel, as with a magic wand, all delays of trial for state offences, and all illegal imprisonments. A few days before the passing of the Habeas Corpus Act, Pepys had been committed to the Tower, under a warrant of the Speaker of the House of Commons, upon a treasonable charge of being a Roman Catholic and concerned in the Popish plot. On the 2nd of June, a week after the passing of the Act, he was brought to the bar of the King's Bench, under a writ of habeas corpus, when he applied to be bailed, but was denied, probably on the ground that treason was expressed on the face of the warrant. He then demanded to be tried within the time specified by the Act. This application was refused, on the suggestion of the Attorney General that he expected further evidence of treasonable correspondence with Trance. Pepys was thereupon remanded to the Tower, and after being brought to the bar a second and a third time, was bailed in the excessive sum of £30,000 to save his securities, who was obliged to appear before the Court of King's Bench 4 times more, on each of which occasions the trial was postponed on the same plea. Afterwards, upon a statement of the Attorney General that the solitary witness, Scott, had refused to adhere to his original accusation, Pepys was relieved from bail in Easter Term, 1680, about a year after his commitment. Narcissus Luttrell, indeed, writes in his diary, in November, 1683, the first week of this term, several persons committed on account of the plot their house plot made their prayers to the Court of King's Bench to be either tried or bailed according to the Habeas Corpus Act, which prayers were accordingly recorded. But Algernon Sidney was sent to the Tower on the 26th of May, 1683, and was not tried till the 21st of November in that year. Narcissus Luttrell mentions, that on the 7th of November, 1683, Speaker Macaulay had been indicted for spreading rumours concerning the Earl of Essex's death was bailed, but in going home was arrested in an action of scandalum magnatum, for £100,000, at the suit of the Duke of York, and carried to prison for want of bail. From the same authority we learn that Street Nicholas Island, at Plymouth, was kept up as a state prison, supposed to be out of the reach of the writ of habeas corpus, and that Colonel Rumsey, after the contradictions in his evidence at the trials of Lord Russell and Cornish had rendered him too infamous to be used any longer as a king's evidence, ended his days in that place of confinement.